Hi, legal team. First, I just want to say thank you to everyone for your patience as we have worked to get these episodes out. As you will hear, I've been recording during my recovery process from my surgery, and I've been putting the surgery off and finally couldn't put it off any longer. I'm only about 8 or 9 days out from surgery, so I'm still recovering. Also, if this audio sounds a little bit weird, that's because I'm using my office microphone. Because there's been such a long break between our last episode of Marco Marco, I'm going to start this episode by giving a brief summary by reading some excerpts from a really good article in the LA Magazine written by Michelle McPhee back in February of 2023. And then I'm going to give you an update on the current status of the case and give a little explanation as to why we wanted to read so much of the transcript from the court hearing where the parties were arguing the slap motion filed by Erika. Starting with the excerpts from the LA Magazine article written by Michelle McPhee. This kind of sets the stage and will refresh you all as to what happened and how we kind of got to where we are in this case. Stylists were at work creating crystal-laden, feathery bodysuits and bedazzled gold lame bustiers in early 2017 when Secret Service agents in riot gear burst into the Hollywood studio of preeminent costume designer Marco Marco in early 2017 with warrants to search the premises. The raid targeted designers Christopher Pasilla and partner Marco Morante. The Emmy Award-winning duo behind costumes for HBO's We're Here, RuPaul's Drag Race, and outfits worn by Britney Spears, Katy Perry, and other colorfully adorned superstars. Now, after one-time powerhouse LA lawyer Tom Girardi was indicted in 2 states, questions are being raised about the reason this raid took place in the first place and why Pasilla was essentially ruined because of it. That's because the investigation had been sparked by singer Erika Jayne, one of Marco Marco's best customers. Jayne had accused the designer of overbilling for her costumes right around the time the financial house of cards, built by her now estranged husband, was beginning to collapse. What the designers didn't know as the devastating ordeal unfolded was that Jayne had called in a favor with a friend of her husband, Robert Savage, the special agent in charge of the Secret Service Los Angeles field office, complaining that she had been built. In an unusual move, which was first reported by the LA Times, Savage assigned the complaint to Secret Service agents. According to a federal indictment, Jayne told the agents that she had given the company access to her American Express credit card for custom costumes she wore during her singing appearances. She didn't keep or review invoices, she said. The design duo, quote, knowingly and with the intent to defraud, caused charges to be made on Erika's American Express credit card without authorization, the indictment stated. Pasilla denied the charges to authorities, but by the time he went before a judge, the damage was done. His brother, Jonathan Pasilla, and his husband, David Lewis, each put up $50,000 to bail him out of federal detention. Pasilla had to surrender his passport and submit to drug testing. Months later, according to court records, his brother suddenly died. Just one of a series of tragedies the designer faced as his company was thrust into chaos and faced the possibility of years in federal prison as the charges loomed over him for 5 years. The government sought multiple continuances in the case as they struggled to gather evidence, which prosecutors were forced to admit was lacking. Amid this lengthy process, in 2018, Agent Savage retired. 2 years prior to this, Girardi had represented Agent Savage in a case against a car manufacturer that raised eyebrows with a federal judge. After a gamble on gaining a bigger settlement failed, Girardi personally paid Savage $7,500. The same month that cash payment was made to the special agent, Agent Savage arranged for agents in his department to meet with Tom Girardi's wife, Erika Jayne, about her excuse for a massive American Express bill. Federal agents who were digging into Girardi case's financials with the same zeal they dug through Pasilla's personal income would find that from 2010 to December 2020, the lawyer and CEO of the firm, Tom Girardi, fraudulently obtained more than $15 million that belonged to Girardi case's clients. The many clients that they are accused of ripping off include a child paralyzed in a car crash and a man severely burned in a work explosion. Now that we've gone back through that little recap, back to the Marco Marco case. As a reminder, Chris Pasilla of Marco Marco filed this case against Erika Girardi and her assistants, Leia and Mikey, American Express, and the Secret Service agents, including Agent Savage, Agent Henderson, and Agent Skarnas. And Chris filed this claiming that Erika and her assistants, with the assistance of those Secret Service agents, concocted a false claim of criminal fraud against Chris Pasilla so that the Girardis could get a significant reimbursement from American Express. So we are going to be reading portions from the transcript of the hearing on Erika's slap motion filed by Erika in an effort to get the case against her and her assistants, Leia and Mikey, dismissed. and then I will tell you how this turned out. I will be reading the portions of the transcript that correspond to Chris Basilla's attorney. Cesie is going to be the judge, and John is reading the part of Erika's attorney. I wanted to read this because this transcript is an excellent example of our legal system working the way it should. Both sides provided excellent advocacy for their clients, and the judge was clearly working hard to be fair and was educated on the facts and legal issues and asked really good questions. Quick note here, we have edited some of the transcript. We're not reading you the whole thing. That would be a lot. So these are excerpts from the transcript. Cesie, would you like to be the judge?
Okay. Rather than write out a tentative, I just thought I would orally address some of the issues here, consistent with what I said in regard to the ex parte application. The defendants have laid out a legally, technically understandable argument, but that is not to say that it's a persuasive argument, because the problem is that at some point it assumes they get all of the inferences and the benefits, which is not the case, obviously, under either a motion to dismiss or on summary judgment in regard to the evidentiary motion to strike. Rather, what Basilah has done is laid out an understandable, plausible argument saying that his prosecution would not have arisen but for false statements that were made by the Erika Girardi defendants, as those are defined in the pleadings and are here the moving parties. When one looks at it that way, there is a lot of merit to that. I guess to summarize here, what I'm struggling with is what does California law say if the appropriateness of a motion to strike is inextricably entwined with the merits of the dispute?
Basically, the judge is saying, look, there hasn't been a ton of discovery done yet. The defendants are filing various motions, but I need to know what the state law says because this is a federal judge, and I need to understand what the authority is for not allowing the case to go on because the plaintiff has laid out a plausible argument.
I also think the last portion to me is saying something slightly different. It's saying that because a motion to strike or an anti-SLAPP motion is based on the statements that are made, how can you find in Erika's favor when the entire argument being made and the entire claim is based on her statements that she made being completely false or unauthorized?
By the way, as an attorney, it's so great when you have a judge that is asking really insightful questions and is giving you the chance to do this sort of advocacy before making their ruling. It's saying, I've read this, I still have some questions, I want to hear both sides so I can make the most fair ruling that I can, and here are my preliminary thoughts. Whichever side you're on, you really, really appreciate that because it gives you a full chance to advocate for your client.
Yeah, I guess something we didn't talk about, though, is what a tentative is. So sometimes some judges, not all, will issue their tentative order, which is basically where they think their head is at, and then open it up to argument if both parties want. Open it up to argument, and then you have an opportunity to change their mind or say, yep, judge, you're right. You got it right, judge. And then they can sometimes be persuaded out of it and then issue a formal order. But this judge is saying, I didn't want to issue a tentative order. I wanted to just hear both of your guys' thoughts first. Okay, so he says, if in fact what the communications between law enforcement and the Girardi defendants were lies, and if in fact as a way to throw off that there had American Express as to what had been done, and if in fact those lies were what were seen by the U.S. Attorney's Office and the grand jury as a basis for probable cause, then it's not clear why the plaintiffs would not have a case that would ultimately prove meritorious. Of course, I have absolutely no idea what the facts are or whether that would be the case or not, but it's difficult then to see why I should grant summary judgment at the beginning of the case in a way which I would never ordinarily do. Well, it's because like the whole point of the anti-SLAPP is that you have to prove whether or not you'd be successful in the merits.
So the judge goes on and again makes your point again, says he's, again, being a good attorney, can easily anticipate where the court's going to go with something.
It either clearly is protected speech unless the allegations are correct. And if the allegations are correct, then it couldn't possibly be protected speech because essentially it's its own crime. A contrivance to fool the U.S. Attorney's Office and American Express. So that is issue number one. So it's basically like a catch-22 is what he's saying. Because the whole point of the anti-SLAPP is that you're supposed to protect people from being sued based on protected speech. But if the protected speech was the entire crime, should it be able to proceed? And then issue number two is then if, in fact, on the merits and whether there is the likelihood of prevailing as that is narrowly defined under California law, what should be done in the absence of any discovery whatsoever? So again, I'm not seeing, and perhaps I missed it, and I invite the defendants to explain to me on this, assuming that more or less the allegations here are true, what is it legally that cuts off the liability? I mean, it seems to me that at most you might be saying, well, based on these other things, the admissions of Mr. Sela, how it looked at the time, one could imagine probable cause in the absence of what was said by the Girardi defendants. But there is no particular reason, it seems to me, that the U.S. Attorney's Office would have pursued this or believed that in the absence of what was done by the Girardi defendants, or at least has been alleged. Again, I don't know what it is they did. And the final things, it seems to me, the defendants are underestimating is a point that Mr. Sela's lawyers clearly made, and that is the significance of the dismissal at all. The fact is that the U.S. Attorney's Office does not lightly dismiss a case that has been indicted. It just doesn't. And all of us in the white-collar community here in Los Angeles know that perfectly well. And I think here that the strength of the inference, which can be drawn from this very peculiar and rare dismissal, are much greater than what the defendants are willing to admit. So there is my tentative.
Yeah, he's basically saying, look, like Cesie and I were saying earlier, it's incredibly rare for the U.S. Attorney's Office to dismiss something, especially in this way. And the statements that they're putting in the anti-SLAPP motion are the statements that would be, like Cesie said, the crime. So it's like, how do I say this is protected speech, especially before any additional discovery?
I mean, the cases have been dismissed based on this amount of discovery. It's usually right. It's basically it serves the same purpose as a motion to dismiss, just with additional evidentiary support and for a different reason. But it does happen.
Okay, next we will be hearing from Erika's attorney, who is being played by John.
Your Honor, as I said before, my name is Evan Borges, and I welcome all of the questions posed by the court. I really do. And if I could have a little time to go through, I think I could answer the court's concerns.
Counsel, that is why we are here.
So let me try this one at a time. The first concern that I heard is that if this is all a contrivance, and these were just pure straight lies to law enforcement or the U.S. Attorney's Office, then there may be issues on prong one on whether it's protected activity.
Okay, for the non-lawyers listening, or the non-law students listening as well, when Erika's attorney says protected activity, he's talking about protected speech under the First Amendment.
Well, counsel, it is certainly possible to, or the law expects a court to be able to disaggregate false statements or misrepresentations from other statements, because that happens all the time in criminal cases, where if the affiant makes a false statement, it's supposed to be kicked out. But if the remainder of the evidence supports the warrant, then the warrant doesn't need to be quashed or the evidence suppressed. But at the same time here, given the significance of this and how foundational the alleged false statements were to sort of getting this whole investigation going, what precisely do you believe are the pieces of evidence that indisputably gave rise to probable cause in the absence of any of the allegedly false statements?
Okay, translation again for the non-lawyers here. The court is calling out Erika's attorney and saying, tell me exactly why Erika had probable cause to believe that Marco was stealing from her. Give me some specifics.
Easy. I really mean that. It's his words and his writings. And it's disturbing, Your Honor, when one goes through the sequence. And I'm going to. And I discussed, which I'm about to do, evidence that is not mentioned in the complaint. Let's be fair. The undisputed facts are September 19th, 2016. Ms. Girardi now has the app that gives her alerts of charges. They contact Mr. Celia. He says, sorry, it was a mistake. They say, no problem. They give him the benefit of the doubt, okay? And this all begins because her husband had complained to her that the charges were excessive without any specificity. So then the next material event that occurs is December 1st, 2016. December 1st, it turns out, based on Mr. Celia's evidence and his opposition to our motion, at 7-something minutes in the morning, he puts through these charges, okay? Within 5 minutes, Michael Minden texts Mr. Celia and says, what are these, okay? Mr. Celia responds, and this is Mr. Celia's text message that says, and I'm quoting, okay? That is very wrong. What the fuck is going on? I'm sorry, I'm calling, meaning ambulance. Now, I had this same issue with another client a week ago. My apologies. Time for a new bookkeeper. Now, here is what is important, okay? And I think this is really important if we are here to deal with the truth, which is the entire premise and thesis of Mr. Celia's complaint is that every single one of these charges was authorized, and she, Erika Girardi, she knew it. Her assistant, Leia, knew it. Mikey knew it. And they have known it from the beginning. And this is all concocted. That is what they are saying now, more than 6 years after the event in question or the events. But here, let's look at what Mr. Celie said contemporaneously on December 1st, which is, quote, "Okay, that is very wrong. What the fuck is going on? I'm sorry. I'm calling them now. I had the same issue with another client. My apologies. Time for a new bookkeeper," end quote. He had made the charge 5 minutes or within 15 minutes of sending this text message. In their opposition, and with his opposition declaration, he says that this text clearly establishes that Mr. Celie had no knowledge of the charge. And he was just, this is called a client courtesy text message. Well, excuse me. He had just preceded it within 15 minutes of sending this text according to his own evidence. And when one reads this text, this text is, "What the fuck is going on?" That is someone who is purporting to convey that they don't know what the basis for the charge was. But that same person had just that charge. So we'll talk about the thesis and premise of their case, which is that my client is supposed to be omniscient about all these charges. And my client is supposed to know that it would be baloney to have a suspicion about any of those charges. But Mr. Celie is saying, well, nothing that I said contemporaneously at the time matters, because what he said is completely contrary to someone who believes that every single charge is fully substantiated, or can be fully substantiated, and has been approved. He says, okay, that is very wrong. Those aren't the words of, he admitted there was something wrong. In this context, this is incriminating. And frankly, the evidence is also undisputed that the same day, and it's later in the text message exchange, Michael Minden says that Miss Girardi is looking at past invoices or past charges to make sure they aren't any other mistakes. And Mr. Celie responds, yeah, I already spoke with her. We're going to get it together. Well, what did he do? And this is extremely important because, once again, the thesis of the complaint is it's all easily conclusively demonstratable that every single one of these charges was authorized. Well, later on, December 1st, Mr. Celie sends over invoices. Now, granted, there's not a lot of time to be able to put them together, but these invoices only supported about, I would say, it's in our opening brief, only about $174,000 of $930,000 total in charges.
Sidebar here with our legal team. What Erika's attorney is doing here is saying a lot of words when really this is simple. He could have said this in 2 sentences by simply stating, Your Honor, the probable cause that my client had to believe that the charges were not correct were Mr. Celie's own words when he said there's mistakes on December 1st.
So it was not full support at all. And he is saying it's conclusively demonstrable. Well, he didn't do it then. It doesn't end there. And this is extremely important because he knows as of December 1st that she's looking at this. His client is looking at it. And he has asked for invoices, which he has provided in part and woefully in part. What happens next? And this is, to me, the most important piece of evidence in the motion. And it's Mr. Celie's email of December 8th, 1 week later. And he says, these are his words. He took the time to get on the computer, or however he sends emails, and sends this email. He says, quote, I have been going through orders and credit card statements over and over, and I'm clearly seeing mistakes, quote.
Legal team sidebar here. Admitting to a mistake is not the same thing as purposefully and intentionally committing fraud, which is what Erika accused Chris of. The 4 essential elements of a crime of wire fraud are that the defendant voluntarily and intentionally devised or participated in a scheme to defraud another out of money, and that the defendant did so with the intent to defraud, and that it was reasonably foreseeable that interstate wire communications would be used, and that interstate wire communications were in fact used. The second 2 is just, he used a computer for the credit card transaction. But the first 2 elements are really important here because Erika had to claim that Marco voluntarily and intentionally devised or participated in a scheme to defraud her and Tom Girardi, and that was done with the intent to defraud. Admitting that you made a mistake is not at all the same thing as intent to defraud or intentionally devised or participated in a scheme to defraud. So that's point 1 that I'm making here in this little sidebar we're doing. Point 2 that I want to make is that, as it turns out, Marco actually had evidence that there weren't mistakes. But that's beside the point here, because what the court is really looking for here is what reasonable belief did Erika have? What probable cause did Erika have to believe that there was intent to defraud? But now back to John reading the transcript of Erika's attorney continuing to make this argument about Marco's statements.
Okay. Okay, let's talk about that statement. First of all, it's nowhere in the complaint, okay? Second of all, we put this evidence in our opening motion. I'm sure there is an explanation, right? No, it's not mentioned at all. Mr. Sale's responsive declaration at all. Pure silence. But what does this reveal? Because if the truth was so self-evident and apparently known to him all along that all the charges were authorized, could be demonstrably proven as correct, kosher, well, why didn't he say that in the email? Why didn't you say this in the email? I'm going through invoices and yep, we are supporting the charges, but please, I need time. Because this is going to be a lot of work. That is not what he chose to wrote. What he chose to wrote is, quote, I have been going through orders and credit card statements over and over, and I'm clearly seeing mistakes, end quote. Now, oh well, it must be that the evidence is only in my possession or my client's possession and not his. Well, that is not true. These are his invoices, his orders. So who is in the best position to figure this out? Mr. Sala? Who is the person who does not say everything is cool, everything was authorized? I'm going to document everything. It's just going to take me time. That is not what he says. That is what he says 6 years later, but that is not what he says contemporaneously. And probable cause is determined by the information in front of the defendant at the time. What he says is, quote, I have been going through orders and credit card statements over and over, and I'm clearly seeing mistakes. What kind of mistake is it? Did he underbill? No, it's not an underbilling, okay? So a mistake in that context has to be an unauthorized charge or an excessive charge. And by the way, this communication conveys a sense of alarm, and it's in context where Ms. Girardi has requested all of the invoices. That is why he's going through them. And he's only provided $176,000 or $174,000 or $176,000 out of $934,000.
Legal team sidebar. I think it's important to put this in context because Chris Sala did not know that Erika was going to turn this into the Secret Service and accuse him of fraud and trying to keep a customer as opposed to show that you haven't done anything wrong to avoid going to jail for an extended period of time and face federal charges and felonies. It's a different exercise. The fact that he was able to go through and find all of these invoices in such a short period of time, I think says something. But Erika's attorney is doing a good job making the most that he can out of the facts that he's got that could potentially be in Erika's favor. All right, back on to John making the arguments as Erika's attorney.
Okay. He says, I'm clearly seeing mistakes. Nothing about it in the complaint. Nothing about it in his declaration. I don't think there's anything you can say about this. Is it a proper inference for a reasonable person reading this to say, oh my goodness, there's unauthorized charges or excessive charges? Now, whether they are innocent or malicious, that is a different determination. The core point of unauthorized charges, that is enough to say to law enforcement, I have concern, okay? Now, maybe we're talking about a few $100s. That's what happens next. And by the way, later in the message of December 8th, 2016, Mr. Sala says, if you have time coming up, I would like to go through and come up with a plan to get this sorted. He says that on December 8th.
Legal team sidebar. I want you to think about the dates here. There was the December 1st text, then there's December 8th. Then think about what's about to happen on December 14th, which Erika's attorney via John is going to describe for you. That's 2 weeks.
So what happens next? They arrange a meeting on December 14th. At that point, Ms. Girardi is wearing a wire. Mr. Sala's own attorney submitted a declaration saying, based on her review of a transcript of the recording, that he said at the meeting that there was just over $100,000 of either overcharge or excessive charges, one or the other. Okay. Well, it's not just over $100,000 of underbilling. Okay. Because what does he say next? He says, we want to pay the money back. Give me time. I'm going to pay the money back. To say that there is just over $100,000 of overcharges or overbilling, and to say that you want to pay them back, these are uncontroverted facts. Forget about everything else.
Legal team sidebar. Again, remember the elements of wire fraud that I read to you earlier and think about this in that context. Admitting you made a mistake and saying, oh, okay,
I want to pay you back. There has to be intent to defraud. Here's the other issue. He's going through the invoices that he has. Remember, Erika admitted that she never looked at invoices and never wanted invoices. So while Marco has gone back after he got raided and hauled off to jail and everything else and found every single text message, email, requesting all of the materials and items and everything else, at the time, he only had the invoices that he had. But again, he wasn't thinking that he was being recorded or that Erika was wearing a wire or that the Secret Service was investigating this or that there was a risk of going to jail. According to Marco, he believed that he was just trying to save one of his best clients. Okay, back to John reading more of Erika's attorney's argument.
Look at this December 1st text message, the December 8th email, the incomplete invoices he provides on December 1st, but then his statements on December 14th. If I was an officer of a bank and they called me into a conference room and said, Evan, we think there's money missing, and I were to say, well, it's just over $100,000. I need time to pay it back. Your Honor, I wasn't underprivileged, but in the neighborhood I grew up in, a kid who is a member of a minority group robs a liquor store of $5,000. He goes to prison, okay? This is an admission of just over $100,000 overcharges or excessive charges. They have to be unauthorized. And to make an offer to repay the money, that is nice, but it didn't get you off the hook. Doesn't get a bank officer or anyone off the hook for what they have done if it's an unauthorized taking, and that is the admission. And so right there, Ms. Girardi has a 12th grade education. There's a lot of statements that are made about her, okay? But is it crazy to go to law enforcement or to continue to pursue the issue with law enforcement based on that evidence, okay? Well, one would think that, Mr. also provided additional invoices at the December 14th meeting. Now, he's been working on it, by the way, since December 1st. That is 13 days. He knows it's important, provides additional invoices. This isn't our opening brief, but nonetheless, the total charges of the $934,000 that are supported by the additional invoices on top of the prior ones he provided on December 1st is something in the range of $400,000, I believe. There is several $100,000 of transactions with no documentary support. Now, of course, it would be different if in his December 8th email and at the December 14th meeting, Mr. Sale had said, I think everything is fine. I think all these transactions are legitimate. He was participating in the transaction just as much as my clients were. He should have said on December 8th, December 14th, everything is fine. I think all the transactions are legitimate. I think you approved them. I'm gathering documentary support. It's going to take me some time. Here is some, and more is coming. That is not what he says. He says the opposite based on his own undisputed statements over and over again. Quote, I'm going over them and clearly seeing mistakes. Just over $100,000 in overcharges or excessive charge. I will pay the money. If that is not enough. And what is the position today, right? I forget. The position today is, well, my clients should have known because everything was in fact authorized. My client should have known that everything was authorized. That somewhere in the vault of somebody there is going to be documentary support, invoices, orders. We should have known all of that. And we knew all of that supposedly. We are omniscient about that. But he's not. He wasn't omniscient of his own charges back in late 2016. And the important inquiry for probable cause, the information that was in front of the defendant at the time. And one last thing, which is that one thing that Mr. Sale did not do, which is after that December 14th meeting, he did not speak with Ms. Girardi again. And he did not at any time come forward, that is 2016 and into 2017, he did not at any time come forward until 2023 with this. I call it a montage. Maybe it's a collage of this cut and paste of different documents and things, this evidence in their opposition, and probable cause and my reasonable basis for having probable cause is based on the evidence and information at the time. And so, incidentally, the evidence is undisputed that Ms. Girardi did not select the 7 transactions totaling $63,000 that the AUSA, as I understand it, presented to the grand jury ultimately for indictment in April of 2017. But none of that underlying, by the way, Your Honor, even one of my law partners said, what if the AUSO or the agents had gone to Mr. Sala and given him an opportunity to explain the transactions before they indicted? I don't know. I wasn't there, and that is not the point. The inquiry here is a citizen making a report to law enforcement. Is there probable cause based on his own admissions? and all the other evidence, supposedly about, financial distress and this and that, and a scam with American Express. I mean, it's immaterial. And
Okay, counsel, I understand the point that you are making that there is independent probable cause that would support it, and therefore that element of the tort would not be met. I'll give you a chance to respond, but let me hear from the plaintiff.
This is Chris's attorney. Your Honor, on the issue of whether speech is protected, our position is lying to law enforcement is not protected speech. There is a California Civil Code, Section 47, that specifically says, and I think it's subsection B5, that specifically says lies to law enforcement are not protected speech. And that includes if those statements are made with reckless disregard to the truth or falsity of the statements.
What about the language which counsel accurately quoted from the California Supreme Court saying how the disputes about that are to be resolved on a motion to strike in regard to prong 1? And prong 1 is the protected speech prong. The Supreme Court case that was cited can be read the way that the defense is arguing. So what is the plaintiff's response?
It seems to me that only certain things are protected, and that the idea of lying to law enforcement or lying to a federal prosecutor is protected seems to me to be antithetical to justice and fairness.
On that, I think everyone in the courtroom would agree. But the point here is for purposes of prong 1, and since those issues can be raised in regard to the other parts of the motion to strike, what do we do with the situation in which the truth or falsity of those statements is in fact what is being contested?
It seems to me that even with the language that with the entire predicate for the statement to the police is fabricated, that takes it out of that language. And here, that is exactly what we're saying. That Miss Girardi and her assistants had, by our showing, no basis to believe when they went to the Secret Service in September that Chris had committed a crime. They had a phone call between Mr. Minden and Chris, in which Chris had indicated that he was not looking at any documentation, but just having a phone call from Mr. Minden, and that maybe there was a mistake, or at best, there was a mistake. He never said in that phone call or in any communication admitted any intentional wrongdoing, any fraud. He never admitted what the defense argues, which is that he made unauthorized transactions. And the whole circumstance of her, meaning Erika, going to the police, it was not like going to the Pasadena Police Department or some random police department close to her home that some person might do if they really thought a crime was committed.
Legal team sidebar. We as fans know that Erika has a son that's a law enforcement officer in California. So that would have been another option for her. But instead, she goes straight to the Secret Service via the Secret Service agent that conveniently had Tom assist him in a legal claim against a car manufacturer.
She goes to the friend of her husband, who has a long-time social and financial relationship with her husband, and solicits his help. There is something corrupt here. There is something corrupt about the whole process, and we will figure that out in discovery. But it certainly was not going to an independent police department or some normal behavioral reaction of someone who thought a crime was committed against them. We addressed this lack of independence in connection with why there should be no presumption from the grand jury indictment arising. But even if it was considered to be protected speech, they cannot win their slap motion because we have set forward a strong case on all of the elements of malicious prosecution. And at this stage of the proceedings, that standard is a very low bar. I think the standard of probability of prevailing has been said over and over again in the case law to be a low bar.
Well, the argument that is being made that there was sufficient evidence for probable cause, even if one excises all of the allegedly false statements and lies that were made. And what is the plaintiff's response to that specific argument?
Sure. And part of the context for why there was no predicate for Ms. Girardi to believe any of these statements of mistake or admissions into admission of a wrongdoing or an admission of a crime, that is a leap. But part of the context of this is that we now know from her declaration that she admitted she had no idea what she spent. She had no idea what things cost. She had no idea what she was charged. At a minimum, that seems to show a reckless disregard for the truth or falsity of her statements to the police. If she went to the Secret Service in September and said, "I am suspicious that he committed a crime," we don't know exactly what she said. But if she's suspicious he's committed a crime against her, she had no basis upon which to make a statement like that if she had no idea what she was charging and no idea what things cost. And that was the context of their business relationship. And this brings me to the question you asked me about understanding how to listen to those admissions that were made, either in emails or the recording. She could only listen to them, and someone putting themselves in an objective position could only consider what they knew, right? We are at a very early stage of this, so we don't know what discovery is later going to show about what she knew and when she knew it. But what we know is that she knew how they did business together.
Legal team sidebar. I just hope so much that discovery goes on in this case and that they are able to get copies of Erika's text messages to Tom Girardi and whoever else because she's made them relevant. I mean, her own attorney here is bringing up, oh, there were these text messages, there were these emails. I cannot wait if this comes out to see what is in those and what she did know.
Chris set forth in his declarations that they had a long-term business relationship that started in about 2013, and that they, Mr. Morante, another declarant who is present in court, and Chris were both at the initial meeting with Ms. Girardi and her assistants, and that she gave them the American Express card for future transactions. And when Chris handed her an invoice for that very first outfit that she was getting the fitting for, she waved it off and said, "I won't need those. I won't be needing those." This business relationship went on for years, and it's not until September 2016, several years into the relationship, when Mr. Minden thinks one of the charges is perhaps high. The assistants and Ms. Girardi were all at that first meeting. We know of the very strong record that Chris has made of the business records that were kept of the texts and communications, the emails, the meetings, the fittings, the out-of-town travel, the numerous orders made for services, not just for the costumes, but of the dancers' outfits and modifications, continually making them more expensive. So it was in that context of knowing that business relationship when he's explaining, when put on the spot and put under pressure by her, where she's threatening legal action and she's threatening this husband who he knows from conversations to her to be very connected and very powerful in Los Angeles. And he's come together as fast as he can to gather some invoices. And very clearly in these conversations, only says perhaps there is mistakes, maybe it's bookkeeping, we've switched to bookkeeper, he's going to look into it. He's the one that asked for the meeting on the 14th where he says he wants to sit down and go through things. He's the one who says he wants there to be an understanding so they can sort things out. That's when she comes to the meeting and she's so accusatory, she's inflammatory, and she's accusing him of stealing $1 million from her husband and cheating her. He is basically saying, let me gather some more invoices. His explanation is plausible. His explanation completely makes sense in light of the business agreement that they have. And to the extent that he makes these statements, they are not admissions of a crime. They are admissions of mistakes. They do not amount to probable cause that a crime was committed. She accuses him of essentially stealing $1 million from her husband, and in trying to preserve this business relationship, as he explains in his declaration when she says, "And what do you think you owe me?" He says, "I don't know, $100,000. And she says, "How are you going to pay that?" And he's like, "Well, I don't know. I would get a loan." These are not admissions of a crime. These are clearly admissions of a businessman who was trying to preserve a relationship. And they are not entitled to all the inferences in their favor at this time. This is a case where in discovery we are going to find out what she knew and when she knew it. And certainly from our showing, we have set forth the very strong record that the business records and business documents will show that it was, as Chris thought, ridiculous that she could think he had taken thousands, hundreds of thousands of dollars from her. In response to this motion, counsel says, meaning Erika's counsel says, why is it coming now? It's coming now because there is a motion to strike. Chris previously did not have a case on which he had to establish all of these business records and all of these communications and all this evidence. But even if they had thought these statements raised some kind of suspicion or heightened the suspicion at the time of this December 14th meeting, all of that evaporates and eviscerates with what happens next, which is that the Secret Service takes all of his computers, all of his devices, all of his business records and invoices and order forms, and now they have all of that. And when the prosecutor, Mr. Pence, is preparing to go to the grand jury and he has a phone call with the Girardi defendants, and in that case it's Erika Girardi and Leah, he asked, is there anything to support? And his exact language is emails, text messages, or invoices to support these 7 charges. And the response is no, there is not. And that is a lie. And now all of a sudden in this motion to strike for pry brief, we have all kinds of exhibits that are emails from the Girardi defendants. Clearly they had emails and access to their emails and access to their communications.
Legal team sidebar. By the way, this is just great. When you are on the other side and you can use your opponent's either statements in court or briefs or memoranda that they have filed against them, that can go a long way. Here, saying, look, their own evidence that they're trying to come forward with now proves that they had access to their emails, text messages, everything else the whole time, and that they could have simply accessed those prior to accusing my client of a federal crime.
So what we have here is kind of a hornet's nest, essentially, of disputed facts. And under the facts that we have set forth, there was no reason for her to believe, both when she initiated the action and in April 2017, just before the grand jury indictment, when she continued that action, she had no reason to believe that he had committed a crime.
Thank you, counsel. Thank you for your arguments. Let's talk about what happened with the anti-slap.
Oh, yeah.
There's 2 elements in the anti-slap. So the first is that the defendants want to prove that the lawsuit stems from protected activity. And here the court found that it did, that Chris's lawsuit stems from Erika's protected activity of speaking in a legal proceeding or in part of a criminal investigation. However, then after that finding, the burden then shifts to the plaintiff to prove that they would succeed on the merits. And if they can prove that, then the lawsuit will continue and the anti-SLAPP will not be granted. So, prong one, like I just said, the court found that the lawsuit did stem from Erika's protected activity, but then also found that Chris has a valid malicious prosecution claim. Do you want to talk about that?
Yeah. To succeed on a malicious prosecution claim under California law, a plaintiff must prove that the prior action, 1, was commenced by or at the direction of the defendant and was pursued to a legal termination in the plaintiff's favor, so in Chris's favor, and 2, that it was brought without probable cause and that it was initiated with malice. Basically saying that Erika and her assistants brought this claim against Chris and then it was dismissed in Chris's favor, so that's true. And then that it was brought without probable cause and that it was initiated with malice. And so this judge believes that Chris can at least make a case for this and get it to a jury, essentially. Not that he's going to win necessarily, but that he's got enough evidence to state a valid malicious prosecution claim.
Okay, so Erika did not win her SLAPP motion. Specifically, the court said that the plaintiff, Chris Pasilla, has met his burden of establishing the probability of prevailing on the malicious prosecution claim in the technical sense in which that term is used in anti-SLAPP litigation.
This case is going to keep going and it's going to be interesting and we're going to keep following it and reporting on it for you. And like I said, we'll post the detailed exhibits to our Patreon. We'll probably post some snippets of it on our Instagram, and I'm really interested to hear your thoughts on this. If you haven't checked out some of the new merch that Cesie has designed, check it out. It's really cool.
I will say the new merch design is an understated way to support the podcast because it doesn't really look like a podcast sweatshirt. I absolutely love wearing it out. I get questions about it all the time. People are like, "Are you a lawyer?" And I'm like, as a matter of fact, I am, but I also have this cool podcast you should listen to. Anyway, thank you as always for listening.
Thanks, legal team.
Thank you. Bye.